Come to order, please. The judges of the New York State Court of Appeals, and His Excellency, the Governor of the State of New York. The Law Day ceremony will now begin. All please be seated.
Good afternoon. Today in this courtroom, as in courtrooms and meeting rooms all over America, we gather to celebrate Law Day, an event conceived nearly 40 years ago by the President of the American Bar Association as this nation's counterpart to the Soviet Union's proud display of military might in celebration of May Day. Law Day is our official rededication to the ideal of American justice under law, which begins with the principle that it is not guns or tanks that protect our freedom and our way of life, but constant attention to the goal of providing, through the rule of law, a full measure of justice to all of our people. Each year, the American Bar Association sets the theme for Law Day that links celebrations coast to coast. This year's theme is E Pluribus Unum, out of many, one, a theme that is rich in meanings appropriate to the occasion. My colleagues on the Court of Appeals and I are fortunate to have with us today to reflect on this theme wonderful friends from in and out of government, all three branches, and I am not nearly so audacious as to attempt to single out the many, many distinguished guests who are here with us today. We welcome each and every one of you to our house. We are especially pleased to have with us, to address today's theme, three outstanding lawyers who are our next speakers: the Governor of the State of New York, George E. Pataki, the Solicitor General, Victoria Grafeo, and the President of the State Bar Association, G. Robert Whitmer. I call first on the distinguished President of the New York State Bar Association, G. Robert Whitmer. I want especially to thank Mr. Whitmer for his enormous assistance to the courts this past year, for his efforts to assure the highest standards among the New York Bar, and most particularly for his vigorous advocacy on behalf of legal services for the poor. Mr. Whitmer.
Chief Judge Kaye, illustrious members of this court, Governor Pataki, Solicitor General Rufeo, and friends. Although it has been my privilege to argue several appeals in this courtroom, never before have I had to decide which way to face. My obvious dilemma is that no matter which direction I choose, I will turn my back on someone. In what may be an appellate advocacy limiting move, I will face the audience and simultaneously adhere to what appears to be the primary rule of our colleagues in California: always face the camera. The recognition of our system of law on this day by the Chief Judge, the Governor, the Attorney General, and the President of the State Bar Association is an important and meaningful tradition which, because of last November's elections, also represents a significant change and opportunity. 3 of us were not here last year, and God willing, 3 of you will be here for several years. In an effort to avoid mixing religion and politics, I restrict my definition of several to mean at least 3. Our system of law is under attack and is questioned more now than ever before in my memory, and desperately needs the thoughtful support and leadership which is present in this courtroom. These attacks and questions reflect fierce winds of change which are blowing through our entire society. In the lifetime of many of us in this room, we have experienced a sea change in such diverse areas as communication, information handling, transportation, international affairs, the family, the influence of religion, our educational system, the organization and staffing of business, and yes, even government. Within the past decade, we have seen external forces drive businesses to become more efficient. At first, it was thought that this drive for efficiency and total quality management would be restricted to the manufacturing segment. But I can tell you from personal experience that the use of computers, the art of right-sizing, and the feedback techniques of TQM are having a significant impact on lawyers who represent business clients. I see no barriers which will divert these forces from lawyers in other areas of practice or from other parts of our legal system. These same external forces pushing for efficiency are now being directed at the legislative and executive branches of government as never before. The recent 100-day whirlwind in Washington and the budget deadlock here in Albany are but 2 highly visible results of this wave of questioning and dissatisfaction which has swept the country. Our legal system, including our judicial branch of government, is not immune from these forces. At first blush, this might seem surprising, since our legal system is in many respects the envy of the world. Developing countries look to us in crafting legal systems which provide for civil rights, contracts, secured interests, intellectual property protection, and other measures which will enable them to improve their economies and provide a better life for their citizens. A European Community Directive, for example, called for member nations to adopt product liability legislation akin to the American system. We can all agree that government and our justice system grant fundamental rights and responsibilities which should be provided efficiently and not frittered away on frivolous pursuits. And all can agree that changes need to be made to improve these institutions and counteract delay and other problems. In determining solutions, however, the issues are too significant and the consequences too critical to hear only one point of view without adequate consideration of others' experiences and needs. This should not be a battle of sound bites. In the short term, this one-sided approach may focus attention on an issue, but that should be only the beginning. Without a dialogue which meaningfully addresses the issues, the acrimony wears everyone down. The resulting legislation often has unintended and deleterious consequences, and citizens turn away disillusioned and doubtful that anything can be accomplished. The efforts in Washington to make changes in our civil justice system provide ample examples of proposals that need to be fully debated, not rushed into law. Is this the defensive view of a lawyer attempting to preserve the status quo? By no means. It is an effort to ensure that access to the courts and legal services do not become a practical impossibility for those in need, for the average citizen, and for the proverbial mom-and-pop business. In our zeal to address problem cases, let's not sweep away our citizens' rights to pursue meritorious claims. Let's first identify the problem before we leap to the solution. We've all seen the ads and the interviews telling tales of a litigation explosion. The missing data would show that civil cases constitute only 21% of the state's caseload, with less than 2% involving torts. In recent years, tort claims actually have decreased, while others, such as those involving matrimonial matters, have grown. And in the push to preempt state laws, there is no mention of the value gained from the development of our current system over the past 200 years. Product liability provisions, for example, have given New Yorkers a forum for redress and a deterrent to the production and distribution of flawed goods. Rather than undertake wholesale reconstruction of the tort system by preemptive federal legislation, we should continue the historical evolution of the law through state courts and legislatures, making modifications to maintain the delicate balance of the needs of consumers and of commerce. Clearly, the actions in Washington should be heard not as distant thunder, but as a movement with profound impact on the states, directly through the doctrine of preemption, and indirectly through possible efforts to make similar amendments in state statutes and through the fallout of changes to the federal system. Representative Henry Hyde, chairman of the House Judiciary Committee, recently denied that the fear of paying an adversary's attorney's fees would exclude citizens from court because, quote, plaintiffs may opt out of the federal loser pays rule simply by filing claims in state court, end quote. The Legal Services Corporation also has been the unfortunate target of a one-sided campaign seeking its demise. This program enables legal services offices across this state to handle over 100,000 cases each year for low-income persons in urban, rural, and suburban areas concerning child support, housing, and other basic necessities. In these financially hard times, the need for these legal services increases daily. The private bar has made heroic efforts to enhance its pro bono work and has volunteered over 2 million hours of service per year to those who desperately need professional assistance. But the bar cannot meet these needs alone, and in fact, the current level of pro bono aid is only possible within the delivery system funded by LSC. This public-private partnership has proved effective, and we strongly oppose efforts to diminish or extinguish this program. In our rush to improve the system, we must be careful to safeguard the bedrock principles and protections which it provides. I would like to share an example of such an experiment which occurred over 20 years ago. At a time when our courts were inundated with cases, Governor Rockefeller removed 2 million moving traffic violation cases from the system and placed them within the Traffic Violations Bureau of the Department of Motor Vehicles. This relieved much of the pressure on the courts, but provided scant guidance on how these cases should be determined in an administrative setting. Over the years, the program managers within DMV came to exercise more and more control over the hearing officers, some of whom viewed this as a threat to their responsibility to render independent decisions. In the mid-'80s, the State Bar Association reviewed the administrative adjudicative system of DMV, along with that of 5 other agencies. I had the privilege of chairing the committee which reviewed the Traffic Violations Bureau and concluded that there had been a price for taking these 2 million cases out of the court system. The price was reflected in overcrowded, shabby facilities, long lines, multiple adjournments, and a lower level of due process, a level which did not violate the constitutional minimum, but which clearly was discernible by the motorists. and which affected their perception of our legal system. I am happy to report that both the facilities and procedures have since been improved, but our experience with the Traffic Violations Bureau should teach us all that significant changes to our legal system should first be studied carefully and debated thoroughly. This is not an area in which sound bites are particularly helpful. There is ample opportunity for the bench, bar, and legislature to improve our legal system, both jointly and severally, to borrow a phrase. Most important are the actions of individual attorneys in counseling clients to advance meritorious positions through good faith techniques, and the responsibility of individual judges to address abuses within their courtrooms. At its heart, our legal system is only as good as the lawyers and judges who work within it. The State Bar Association recognizes this and has vigorously supported our programs of legal education and discipline. Cascading changes in substantive law, procedures, information handling technology, and the need to improve attorney-client relations make obvious the need for a mandatory continuing legal education program. We have supported this legislation in the past and hope that this year a bill can be passed and presented to the governor for signature. We would like to have our continuing legal education program work more closely with our colleagues in government service. The potential benefits are significant for everyone. I am pleased to report that our Attorney General recognizes this opportunity, and we look forward to working closely with many of the talented lawyers in his office. The State Bar Association has also been a firm advocate of a strong professional disciplinary system. We should be ever vigilant to identify those few attorneys who violate our code of professional responsibility and to have them removed from our roles. We in New York are proud of our Lawyers Fund for Client Protection, which in each of the past 2 years has paid $7.5 million to reimburse clients injured by the misconduct of their lawyers. This amount is greater than the sum of such awards made by all of the other 49 states combined, and comes directly out of the $300 biannual registration fee paid by every lawyer in this state. Unfortunately, only 20%, or $60 of that fee, is dedicated to the Lawyers Fund. The remainder is placed in the Attorney Licensing Fund, which is part of the general fund of the state, and only part of that is used to fund the professional disciplinary machinery for lawyers. Approximately $8.3 million is spent on matters unrelated to our legal system. That is wrong. The entire registration fee should be dedicated to fund programs to license, educate, and discipline lawyers. The need is great, and it is fair, although I recognize that this is not the year to deplete further the general funds of the state. Once the state's economy improves, I hope that the legislature will view favorably the bills which have been introduced to seek this result. We also can build on efforts to reduce delay and expense. Laws were enacted in 1992 to simplify discovery procedures and reduce motion practice. The association has proposed additional legislation to enhance pretrial and settlement procedures and rules to strengthen sanctions for abusive conduct in unreasonably delaying or prolonging litigation. Although those of us who work within the system may be comfortable within the current hodgepodge of courts, clearly the citizen who comes to our doors seeking justice cannot comprehend why the system is so complicated. A unified court system has made sense for years, and particularly now when our citizens are demanding greater efficiency. Last year, the Chief Judge and the State Bar Association each initiated studies of the jury system at approximately the same time. The Chief Judge's Committee, chaired by Colleen McMahon, issued a splendid report with 81 specific recommendations. The State Bar has enthusiastically endorsed almost all of these recommendations and has worked closely with the unified court system in implementing several of these initiatives. I wish to mention specifically 2 bills which we support. One would eliminate nearly all exemptions from jury duty, including that currently enjoyed by lawyers. Such a step would enlarge and strengthen the pool of jurors upon which our system depends. The other bill would eliminate the mandatory sequestration of criminal juries. Unfortunately, the O.J. Simpson trial has shown us the pressures which sequestration can impose on a jury. There is no good reason why every criminal jury in this state must be sequestered during its deliberations. We should have sufficient confidence in our trial judges to permit them to decide the issue of sequestration, case by case. In responding to the criticisms of our judicial system, one of the most effective measures we can take is to ensure that the very best and most hardworking people are placed on the bench. A good judge will control the courtroom, will monitor and sanction frivolous conduct, and will modify those few jury verdicts which are excessive. The State Bar Association supports a strong judiciary, which means that judges should receive fair compensation, and they should be selected by a merit system, not our current electoral system, which too often means selection by political leaders with too little accountability and not a meaningful election by the voters. For years, the practice of law has been very attractive, and our profession has skimmed the cream of the college crop. We have a tremendous number of talented, hard-working lawyers, more of whom should be considered for judicial positions than our current system allows. Furthermore, consistent with the total quality management principles which are being applied with positive results in business, law firms, and even government, I suggest a modest feedback program for the judiciary. Periodic and confidential surveys of judges by lawyers who appear in court could be a valuable tool by which judges and the legal system can be improved. Such surveys are already being conducted successfully in 2 counties of our state, Monroe and Erie. Changes to the system will be difficult, but changes must be made. I am reminded of the axiom, if you always do what you always did, you'll always get what you always got, which is illustrated by the story of John and Tom, 2 moose hunters who every year went up into Canada to hunt moose, and last year they did the same. A float plane took them in to a small isolated lake, dropped them off, and the pilot said, "I'll be back a week from now, same place." And sure enough, a week later the plane swooped down to this lake, taxied up to the campsite, whereupon John and Tom start to drag their gear and this huge moose that they had shot onto the plane. The pilot said, "I can take you, I can take your gear, but not the moose. We'll never get off the lake." Whereupon an argument ensued. John finally said, "Look, we were here last year, same kind of plane as this. We shot a moose the same size, and that pilot let us put the moose on the plane." That argument carried the day. The moose goes on the plane. The pilot starts to taxi down to the end of the lake. Before he even gets to the lake, he jams the throttle forward, wheels around. The plane starts to lumber down the lake. Finally, the pontoons are slapping against the water, and as the fringe of trees comes rushing up, they take off, just miss the fringe of trees, except they hit one lone pine tree standing above all the rest and crash down into the forest floor. John and Tom are both on the floor. John comes to his senses, looks over at Tom and says, Tom, where are we?" Tom takes one look around and says, "About 100 yards further than last year." By working together, those of us in this courtroom can make the changes which will not only keep our legal system from repeating the same mistakes, but will enable it to serve better the clients of us all, the citizens of this great state. Thank you.
Thank you, Mr. Whitmer. I'm pleased next to introduce a person we all knew and worked with in her last life when she was chief counsel to Clarence Rapelier, minority leader of the Assembly of the State of New York. In her new life, I expect she will be a frequent and most welcome presence in this chamber, the Solicitor General of the State of New York, and I would like to deviate just a bit from my policy of not introducing our many, many distinguished guests here today, simply by extending a special welcome to the Solicitor General's mother and father, and to her husband, Ed Winders. And I now present to you the Solicitor General of the State of New York, Victoria Grafeo.
Good afternoon, Chief Judge Kaye and the judges of the court, Governor Pataki, State Bar President Whitmer, and other distinguished jurists and guests. The Attorney General, Dennis Bacco, extends his appreciation for your participation in this Law Day. It's been 65 years since an Attorney General hailed from Western New York, so General Bacco is the Law Day Guest of Honor at the Erie County Bar Association right now. Therefore, I'm grateful Judge Kaye offered me this opportunity. The Chief Judge suggested that I mention what the role of the Solicitor General is. The title has led to some interesting misinterpretations since I was appointed in January. As you know, the English use of the term solicitor refers to a member of the legal profession who assists barristers, those who serve as advocates in court. In both the British and American systems of government, the title Solicitor General is given to a deputy of the Attorney General, or its British equivalent, the Lord Advocate. The proliferation of federal cases in the aftermath of the Civil War and the increasing cost of securing outside counsel led Congress to establish the United States Department of Justice and a Solicitor General in 1870. But it was not until 1927 that a Solicitor General was created in New York, and then for the developing an expertise on constitutional issues, particularly state taxation and finance. Of course, that mission was expanded as the responsibilities of government have grown. The Appeals and Opinions Bureau in the Department of Law advises state agencies and public authorities. They defend the constitutionality of state statutes. They issue opinions interpreting state laws and represent state officers and employees in federal and state appellate courts. In summary, the chief responsibility of the Solicitor General is the oversight of the appellate caseload on behalf of the state in order to maintain consistency in the government's position. That and pinch hitting for the Attorney General when he's asked to speak in two cities on the same day. The purpose of Law Day, as has been for more than 40 years, is increased public awareness of our legal system and enhanced respect for the law. As the chief legal official of the state, the Attorney General is vested with authority by the people to preserve and promote respect for the law. How else can we live together as many, united to reach our common goals of opportunity, prosperity, and justice for all? Theodore Roosevelt once said, "No one should be above the law, and no one should be beneath it." The notion of equality before the law is essential. The law must be the common ground upon which the many unite as one. This year's Law Day national motto, E Pluribus Unum, was adopted by the Continental Congress in June of 1782, about 5 years before ratification of our federal Constitution. It predates the law of the land, but remains relevant today as we collectively struggle to embrace the diverse cultures, attitudes, and beliefs that make this state and our nation unique. As important as the law is to all of us, it alone is not the tie that binds our diverse people into a single nation. The unifying force is more personal and fundamental. It is mutual respect. Government cannot legislate such fundamental values. The elaborate configuration of our laws and our very system of government, with its checks and balances, the articulation of individual rights, protection of minorities, are all born out of the recognition that we must have a structure that promotes mutual respect. While popular criticisms of the law and the legal profession may seem especially vigorous these days, we must remember that among the rights Americans enjoy is the right to complain about lawyers. While high-profile cases such as the O.J. Simpson trial bombard the public with endless detail about legal procedures, widespread understanding of the law remains an elusive goal. When it comes to our system of justice, people are drowning in information but are starved for knowledge. There is a critical need for those who work with the law to help people appreciate and respect the value of our democratic institutions. Law Day should not just be a single event honoring the role of our system of justice, but a call for us to protect and instill a deeper appreciation of our rights and freedoms. And we can best secure a peaceable future among so many diverse groups by the examples we set and the work we do today. Last Thursday, on Bring Our Daughters to Work Day, I was in the back of this courtroom and thought how marvelous that the young women in attendance and visiting the court had the opportunity to observe Judges Kaye and Siparik on the bench that day. Such was not the case when we were children, and it illustrates the progress we've made as we work to keep our justice system open and accessible to all people. Whether an elected official, a member of the judiciary or the bar, a law enforcement officer, or court personnel, we are the many involved in the legal system. In the daily performance of our duties, we create small ripples which eventually form the wave of public opinion regarding our system of justice. So much is needed to counteract the tarnished image of the legal profession. The unwillingness of citizens to serve on juries after viewing months of the Simpson trial. The overcrowded and unacceptable condition of many of our court facilities. The difficulties in securing juries that reflect their communities. And the general lack of confidence in the ability of our system to deliver swift and fair justice. Yet these are not insurmountable problems if we aspire to diligently and ethically fulfill our respective roles. We don't have to search far back into history to find examples of what happens when people in the law do their jobs. We need only look back a week or so to recall the example set by the Oklahoma State Trooper who, in the ordinary course of his duties, stopped a speeding car and made a major contribution to the cause of justice. Now a nation owes him its debt of gratitude. And we have our own examples of excellence and dedication. And the Attorney General joins me in congratulating the recipients of today's Merit Awards. So as we enjoy the arrival of spring and nature's rebirth on this first day of May, the sun's not shining right now, let us also renew our devotion and energies to enhance the public's understanding of the role of the law and government in a free society. We must assist the law to recognize and respect the valuable diversity of our people. Yet we must also help the law assert the common principles that bind us as a nation into one. Thank you.
Thank you so much. It's my privilege next to call upon the Governor of the State of New York, George E. Pataki, for his remarks. In that I made 3 exceptions to my policy to introduce guests of the Solicitor General. I'd like to make 3 more. It's dangerous to depart from precedents. Governor, this is not your mother, father, and husband, but I'd like to extend a special welcome to your Secretary, Bradford Race, to your counsel, Michael Finnegan, and of course to our marvelous presiding justice, Anthony Cardona, and all the justices of the 3rd Department and the State of New York. Governor, in that this will be your first presentation in the Court of Appeals, I want to assure you at the very outset that you have an extremely friendly forum behind you.
Thank you, Chief Judge Kaye, and distinguished members of the Court of Appeals. I wanted to say that I have never lost a case here in the Court of Appeals, but you gave it away. I've never argued one here. At least I'm still undefeated. President Whitmer, Solicitor General Raffio, Administrative Judge Malonis, everybody ignored you, but you're very important to the judges out there. I just want to say it's a tremendous honor and a privilege to be here on Law Day to address you. It is appropriate as well, because just 2 days ago, I was attending my 25th law reunion in New York City. And it was a great time, as reunions always are, and we went beyond the social and started to talk about the times and the tribulations of when we were in law school. And President Whitmer talked about some of the pressures under the judiciary and the legal establishment at the present time. But if I think back, and as we talked about it, we were in law school during the era of Vietnam. And in fact, almost a third of the students in my class did not graduate because they were sent to Vietnam or found some other, in most cases, legal method to continue their deferments. But it was a very difficult time for all of us, and it was a system when the legal structure of this country was under tremendous stress. And yet, because of the rule of law, because of the institutions that were created, because of, ultimately, the people's respect for the law and our institutions, we got through that time. And, as I talked with my roommates and friends about their trips to Washington to protest, we thought about the tremendous beauty and intelligence of our democratic system of law in this country. And of course, right after we got out of law school, we went off to our various careers, and we're faced with the next major crisis. And again, one of the major legal crises to face this country in its history, which was Watergate. And once again, the way this country, the way our legal and political institutions dealt with that crisis showed again that the rule of law, that the brilliance of the institutions and legal system of this country were able to overcome any crisis. And when you think of that, it shows that respect for the law, and most important, equal application of the law to everyone, whether it's a common citizen or the President of the United States, is the brilliance of our country that has allowed us to have this more than 200 years of unprecedented freedom and opportunity. And today is Law Day, and the American Bar Association, as the Solicitor General indicated, has chosen e pluribus unum as its expression for this day, out of many, one. And it is, of course, what has happened in this great country, a country that has attracted people from around the world to our institutions to take advantage of the freedoms and opportunities that are here to a greater extent than any place else in the world. It is when I think back on my own family and on my own children, when I think ahead to them, it's the tremendous diversity within our own family, and now the diversity within the country where we are attracting people to New York State, immigrants from around the world, from the Dominican Republic, from Haiti, from the Orient, from Asia, from Ireland, from all over the world to come to New York again to take advantage of the opportunities and the freedoms that we have here. It is important on this Law Day that while we celebrate that diversity, while we honor the commitment and the unique talents and traditions and abilities that people from around the world bring to this state, that we again recognize the importance of e pluribus unum, the importance that out of many we become that one. And there are many great institutions, many great traditions in this state and this country that make that happen, like our great public school system, but none is more important than our system of law. So on this Law Day, it's important that we do think about the primacy of our legal system, of respect for the law. And as an aside, that's why I'm going to sign the 65-mile-an-hour speed limit into law. We need respect for the law. But we should rededicate ourselves to that concept of the primacy of law, that there can only be one standard of law for all New Yorkers and all Americans, that that standard has to not only be respected by all of us, but it has to be applied by those in the judicial system, in the law enforcement areas, in those areas responsible for application of the law, with one standard as well. Just as our founding fathers had the brilliance to understand that in creating a system of laws, a system of politics, a system of institutions that would respect individual rights and freedoms, but at the same time encourage a common standard, so we today should rededicate ourselves to making sure that that common standard is in fact a reality. So all of us have the ability, not just law day, but every day, to teach respect, to show our understanding of the importance of one standard of law and respect for that by all New Yorkers, by all Americans. And those in the judiciary, those in law enforcement, those in the institutions charged with applying that law have to redouble your efforts to make sure that just as we have one standard of respect, we have one application of the law in a way that is fair and just for all New Yorkers and for all Americans. E pluribus unum. It's a great slogan, but it's got to mean more than that. And on this law day, let us work to make sure that that meaning is real, that that sense of respect for the law, that out of many, one standard of law, one application of the law, one sense of respect for the law applies to all New Yorkers. Thank you very much.
Thank you, Governor. I assured you that you had a friendly forum behind you, and as you see, you had a most receptive one in front of you as well. It's no overstatement when I say that I have never sat in this courtroom or prepared to sit in this courtroom without learning something new, and that is amply true today. Thank you, Governor Pataki, Solicitor General Grafeo, and Bar President Whitmer for your thought-provoking and inspiring remarks, which have indeed enlarged our understanding of today's theme. To be frank, I have sometimes in the past felt distinctly less than enthusiastic about some of the Law Day themes that have been devised by the American Bar Association, which are invariably amorphous and at times have seemed downright squishy. Together with its choice of theme, the Bar Association even sends along a catalog offering Law Day mugs, buttons, posters, T-shirts, and hats. Now, I've promised my colleagues, though it was tempting, I might say, that I would not wear my Law Day hat for today's ceremony, and I have to add that the governor refused the offer as well. But on further thought, I understand the need for the very broad theme, and even the need for all the kitsch. Indeed, I've come to recognize that there's a genius behind it, because through the single theme, the Bar Association sounds a clear bell that is heard in schoolhouses, courthouses, and meeting halls all across America, joining our marvelously diverse people, young and old, rich and poor, people of all races, religions, backgrounds, occupations, and predilections, in one unified tribute to the rule of law by which this nation lives. From one theme, many celebrations. And being the marvelously diverse people Americans are, we have so many different ways of celebrating, so many different ways of expressing our commitment to the rule of law. Somewhere, you can be sure, people are indeed wearing those hats and shirts and buttons as they meet to consider the theme and its meaning, e pluribus unum, out of many, one. My own preparation began with a search of the literature. That's, of course, a very judge-like way to approach any subject. I learned that the phrase, jangling on our pocket change, is actually derived from an ancient poem having to do with the careful planting and tending of a garden. The plants were then used to make a splendid mixture, the ingredients each maintaining a separate look, but in combination, taking on a new flavor all its own. What a fitting symbol for these United States, each state maintaining its individual distinction, yet enlarging and enhancing its own strength through the power of combination. What a fitting symbol for Americans, a distinctive, vibrant patchwork of separate communities and identities, a pot that has thankfully never melted, a people diverse yet essentially united in their dedication to the common values of tolerance and reason and equal justice under law. As I prepared weeks ago for this day, it struck me that on Law Day 1995, we could speak with a great deal of pride in our progress toward equality under law, but surely not with any complacency about the success of this nation's noble experiment. In point of fact, 200 years after our commitment to e pluribus unum, still many feel unable to find their foothold in the American promise, prompting resentment and sometimes even acts of violence. Ironically, some of our fiercest debates today center on issues like affirmative action and foreign languages in the schools, gay rights and aid to the poor. In essence, how we can deal with and best accommodate our diversity. Issues such as these remind us that our vibrant garden of individual differences, united under the canopy of equal justice through law, needs constant, careful tending. And however appropriate it seemed this year to talk about the central role of the law in guaranteeing justice, that theme became eerily prophetic nearly 2 weeks ago on April 19, when disaster struck the Justice Building in Oklahoma City. Just over our heads today, as throughout the country, flags fly at half-mast, reminding us that on Law Day 1995, we are a nation united in mourning human loss and tragedy, mourning a hideous breach of law and a devastating blow to the American spirit. From the rescue worker holding the lifeless child, to the multitudes gathered to grieve and to comfort, this disaster has caused Americans coast to coast to join hands in a symbolic bandage across our wounded heartland. Out of many one, many sentiments, many emotions, many words, but one voice, one commitment to justice that endures though its edifice is shattered, a commitment to seek out and punish the perpetrators, but above all, to continue to live by our rules, not to live by their rules. On Law Day, we reassert our dependence on the rule of law, which began with the Constitution and is renewed every single day in legislatures and courthouses, in executive chambers and law offices, in law enforcement offices and in administrative agencies, in so many things we do. Respect for the law has proved that it is the most effective guarantor of a free and peaceful society, the most effective weapon against those few hate-mongers who would dishonor it, and the most effective avenue to equal opportunity for the many diverse communities that make up America. Whether celebrated with hats or T-shirts or solemn declarations, on Law Day, we gather simply to reaffirm that despite the difficulties and despite the disappointments as we struggle to do even better, it is impossible to imagine living any other way. Thank you. Call upon Chief Administrative Judge Malonis. You see, Governor, we haven't been ignoring him. We've reserved an entire special part of the program for Judge Malonis, and this gives me an opportunity again to make 3 exceptions and introduce the deputies, Judge Cozier, Judge Traficante, and Jonathan Lippman. And I'd like to call on Judge Malonis to make the presentations of awards.
Chief Judge Kaye, members of the Court of Appeals, Governor, distinguished legislators, jurists, and guests, each year we celebrate Law Day by recognizing those whose works and deeds have enhanced the court system, improving the service that we provide to the public, and strengthening our ties with the community. I am very pleased on this Law Day, May 1st, 1995, to honor 6 individuals whose knowledge, dedication, and enthusiasm have made the court system and our community better for all of us. On behalf of the recipients and the court system, I would like to thank Chief Judge Kaye and the Associate Judges of the Court of Appeals for once again making these presentations a part of the Law Day program. I'd like to ask Robert Pope and Bruce Kahn to come up, please. I'm sure that all of you were intimately familiar with Chapter 261 of the laws of 1993 when they were passed. Well, neither Robert Pope nor Bruce Kahn were supervisors in the Nassau County District Court. The law provided for the Nassau County Accelerated Adjudication Program, which mandated the court to, quote, take whatever steps are reasonable and necessary, end of quote, to dispose of approximately 480,000 moving traffic violations. For the court, that meant introducing automation into the traffic department at lightning speed. Robert Pope, principal court clerk, and Bruce Kahn, management analyst, rose to the task, researching the appropriate and necessary wiring for the offices, computer equipment, software, and related components needed to build literally from the ground up a state-of-the-art system for automating the processing of traffic violations. After identifying and buying the correct equipment, Bob and Bruce installed it themselves. In the process, they became experts on workstations, printers, network interface cards, 10 base T-hubs, and 10 base T-jumper cables, and building networks. Still not satisfied with their work, they personally tested, adapted, and modified the programs and helped train the department staff on using the new equipment. At the same time, both Bob and Bruce continued to meet their ongoing assignments of running, respectively, the traffic department and the central accounting department, both more than full-time assignments. The Nassau County Accelerated Adjudication Program has operated with the utmost efficiency, thanks in very large measure to the dedication, ingenuity, and unfailing good humor of Bob Pope and Bruce Kahn. The district court can now boast of a modern, efficient computer system that fully supports the crushing caseloads of the traffic department and can take great pride in staff that is fully, quote, computer literate. This past year, the staff and the computer system developed by Bob and Bruce for the program collected over $5 million for the state and more than $1.5 million for the local government. Not bad. As one who stopped using his VCR when my daughters went to college, I am particularly proud to honor Bob Pope and Bruce Kahn on Law Day and to present them with the 1995 Merit Performance Award. Bruce? Thank you, Bob. Thomas A. Dorey, Jr., please come up. Senior Court Officer Sergeant Thomas A. Dory, Jr., 9th Judicial District. Today, the entire court system joins the 9th Judicial District in honoring the volunteer spirit of Thomas Dory, who so generously gives his time and energy to critically ill children. Sergeant Dory serves as a senior court officer sergeant throughout the district, certainly a full-time occupation, yet is able to devote his leave time each summer to serving as a counselor at the Hole-in-the-Wall gang camp for children with life-threatening blood diseases. At the Hole-in-the-Wall gang camp in Ashford, Connecticut, founded and supported by Paul Newman and named after the legendary outlaw hideout, Sergeant Dory unstintingly provides children with love, attention, helping them learn how to fish and swim, and simply how to enjoy life. Every camp begins at 6, runs long into the evening, and the pay, as described by Sergeant Dory, is extraordinary. Hugs, smiles, laughs, and a lot of love. The daily fare includes the effects of chemotherapy and radiation and other life-saving techniques. These are handled in a normal cost by remarkable counselors who, like Sergeant Dory, rejoice with the campers over an, quote, ugly scar contest, end of quote, and deal with triple lumen catheters without missing a beat. Tad, as Sergeant Dory is known, does this day to day, year after year, keeping in contact with campers and fellow counselors. When asked if it is not depressing to work with such sick children, Tad's response invariably is the following, quote, just the opposite. The children have so much strength. They live life to the fullest and cherish each moment. If I can contribute to their happiness and well-being while at camp, not try to change what may happen to them, I've attained my goals. This zest for life is nothing new for Sergeant Dory. In addition to being a security officer, he's a registered nurse, an emergency medical technician, a United States Coast Guard reservist. To these efforts and to the group at the Hole-in-the-Wall camp, he brings commitment, dedication, and a joyous human spirit. We are very pleased to honor this exceptional employee with a 1995 Merit Award. Romanita Pinto and Gladys Rodriguez. The court family is proud to include the staff of the children's centers created under the auspices of the Permanent Judicial Commission on Justice for Children. The centers provide a safe haven for children whose parents are in court and link families with needed services. This year, we are pleased to honor 2 key individuals who have made the idea of children's centers a reality for many parents and children coming to our courts. Ms. Romanita Pinto, the director of the Children's Center in Erie County, and Ms. Gladys Rodriguez, director of the Victim Services Children's Centers in New York City, have improved the lives of many New York children through their compassion, dedication, and goodwill. The bright decor of the centers is matched by the care that Ms. Pinto and Ms. Rodriguez provide to both children and parents, never failing to listen to parents' concerns or attend to children's needs. These 2 professionals have transformed their corners of the courthouses into friendly and happy places for children to spend time productively instead of having to wait in the courtroom. Under their careful guidance, children paint, listen to music, play and read, and parents are free to focus on the business at hand. The warmth and generosity that Ms. Pinto and Ms. Rodriguez bring to children have extended to entire families. Ms. Pinto's dedication to the families in the center is legendary, including providing a meal for a homeless family and comforting a parent facing the loss of custody of a child. Ms. Rodriguez truly believes that nothing is impossible. She has diffused countless tense and difficult situations with her infectious humor and has enhanced the professionalism and services offered at the centers in New York City to the highest possible level. We are delighted to welcome Ms. Pinto and Ms. Rodriguez as part of the justice system and to honor them on Law Day with a 1995 Merit Performance Award. Willie Figueroa. Willie Figueroa is being honored today with the Merit Performance Award in recognition of his outstanding services as supervisor of Times Square Express, the bulk mail house servicing the Midtown Community Court. After serving 4 years in prison on drug charges, Mr. Figueroa had the opportunity to become involved with Times Square Express. Through his efforts, Times Square Express has become a successful business and, perhaps more importantly, a vital training opportunity for countless offenders. The mail house, which is part of the court under the umbrella of the Fund for the City of New York, offers bulk mailing services to neighborhood, non-for-profit organizations, and civic groups. It is staffed exclusively by defendants sentenced by the Midtown Community Court to perform community service, and by former defendants who volunteer their work. Mr. Figueroa supervises offenders and volunteers work, manages the mail house business, and seeks out new non-for-profit clients. To date, Times Square Express has produced nearly 1.5 million pieces of mail for 75 local organizations since its inception, and with Mr. Figueroa's help, is looking to expand in a large space. Willie Figueroa has not only made Times Square Express a successful mail house that serves the not-for-profit community, but also has created a place where sentenced offenders learn from someone who has been in trouble himself. Using compassion and resourcefulness, Willie Figueroa has helped prostitutes enter safe houses, to turn their lives around, and has assisted offenders seeking to enter long-term treatment facilities. Mr. Figueroa is perhaps best known for his development of a volunteer program where he accepts community service graduates as interns and helps them learn job skills. Along the way, he gives them support and encouragement that they need to continue and meet their goals. The court system is pleased to include Willie Figueroa as one of its own, an accomplished worker who shares his vision and energy with those in need. We are delighted to pay tribute to Mr. Figueroa and all that he has accomplished at Times Square Express, for the Midtown Community Court, and for New York City. Thank you all.
Thank you, Judge Malonis. That brings our Law Day program to a close. On behalf of my colleagues on the Court of Appeals, I'd like to thank you all for being here with us, and I hope that you can linger for a few moments so that we may come down from the bench and speak with you personally. Thank you.
Very nice to be here. Good to see you.
Very nice to meet you.